Good afternoon, everyone. My name is Dana Buchin, and I am the chair of the immigration practice here at MRSA Carolina. Thank you for joining us today. Our goal here at MRSA continues to be to bring more educational opportunities like this to you, to hopefully give you a better understanding of some of the issues we are facing today. All callers are in listen-only mode. If you have questions during the presentation, you can write them in the questions box of your webinar toolbar, and we will answer them at the end of the presentation. All of today's participants will receive an email from Jackie Rowe after the webinar with a PowerPoint presentation. And now, to begin, I would like to go over the new changes implemented as of January 22nd, 2017 in regards to the new I-9 forms, as well as a few other regulations that were passed just by the Obama administration on their way out. So I do also have, towards the end, some updates on the new Trump executive orders and other policies that may affect employers of foreign nationals. But most of the presentation will deal with the new Obama regulations as of January 2017. The new regulations and policy guidance have to do with changes to the I-9 forms. Ever since January 22nd, 2017, employers are now required to utilize the new I-9 form for new hires. Now, employers have the same storage and retention policies as with the old I-9 forms. Basically, I-9s must be retained and stored by the employer for 3 years after the date of hire, or for 1 year after employment is terminated, whichever is later. As I mentioned, the new I-9 was announced in November 2016, but is mandatory as of January 22nd, 2017. The form is now easier to fill out electronically, and it streamlines certification for certain foreign nationals, specifically some employment authorization document holders. It clarifies the list A, B, and C of documents that can be presented in support of the I-9 forms. As everyone knows, an employer is not at liberty to suggest particular documents to be presented, but rather has to present the list A, B, and C sheet to the foreign national and have them pick from the list which document or combination of documents they will provide. The list A documents has been revised. Now, this is the list where there are documents that automatically prove status and employment authorization. For example, U.S. passport or passport card, green card, employment authorization card, foreign passport with I-94, which allows employment incident to status, and many others. There's a full list on the USCIS website. We're not going to go over each and every one of them, but to boil down what could be on list A, what is on list A, basically any document that proves both immigration status and has a photograph to prove identity. You should expect such documents to be on list A. List B documents, it's not an exhaustive list. We don't have enough paper space or space on our presentation, and a complete list is of course on Form I-9, but list B documents are basically U.S. driver's license or state photo ID, military ID, voter registration card, school or medical records for those under 18. Evidently, the way the list B works is only in conjunction with a document on list C. So the list C has also been slightly revised, and there's an unrestricted Social Security card that can be provided on list C documents. List C documents also original or certified copy of U.S. birth certificate or a certification of birth abroad. That's the list C. What other good news, and I call it good news because in reality, this regulation that was passed right before, in January of 2017, it's good news for employers because it is intended to streamline all these practices about hiring and dealing with foreign nationals on your payroll. And so, for example, one such measure was streamlining the renewal process for the employment authorization. A lot of your foreign national employees might present you with an employment authorization document that has a specific expiration date. Now, so that I can explain to you the purposes behind this regulation, it is useful to understand what happened before. Before, a particular foreign national had an employment authorization document expiring, let's say, December 31st, and then they had to renew it. The very process of renewal takes up to 90 days. And what happened if they didn't get their renewal application in time 3 months before the expiration? It used to be the case for most categories. It used to be the case that they would have a gap in employment if there was, because of this 90 days that the government took to process the application. No longer the case under the new regulations for quite a few categories of employment authorization document holders. So, for example, the new regulations allow the EAD holders, EAD means employment authorization document holders, to continue employment with an expired EAD card for 180 days automatically, as long as they timely filed their EAD renewal, even 1 day before the expiration of their current renewal. The EAD and the other conditions are that the EAD renewal falls under a category acceptable for automatic extension. In other words, the regulations automatically extend only for certain categories, but not all categories of EAD holders. And a complete list of what those categories are listed on the website of the USCIS. It's a bit overwhelming when you look at it because there's all sorts of categories you've never thought existed. Now you take a look at that list and you're going to find yourself thinking, how will I be able to tell the difference between these very unique categories? How will I be able to tell if it's in that category or the other? This is how. You look at the EAD category on the current card and you match it with the list, that's a complete list which is on the USCIS website of all these categories that are eligible for renewal. If it's the same code, because they work by code, if it's the same code, then that EAD is subject to, it's eligible for automatic renewal for 180 days. The other condition is that evidently you don't get a new EAD card before the expiration of the current one, because if you do get a new EAD card, then there's no purpose for the 180-day extension. You just got a new EAD card. If all these conditions are met, if you concluded that this is an EAD that's subject to automatic renewal, then the expired EAD card, together with a USCIS receipt notice demonstrating timely filing of that extension, will be enough for I-9 verification purposes for employment eligibility. If any of this sounds overwhelming, it's because it is overwhelming, and what I usually advise employers in situations like this, because you cannot possibly be expected to know all immigration categories and how they work and how they're documented by the government, I would advise calling an immigration lawyer. It only takes probably less than 5 minutes for a competent lawyer to figure out whether a certain EAD is subject to a 180-day automatic renewal or not. It's not a big deal. Now, as to the new regulations affecting employers of foreign nationals, these, as I mentioned, took effect in January 2017. And most of them are supposed to be good for employers because they clarify practices, they ensure uniformity, and they make it a little easier for foreign labor mobility. So how does it achieve that? Priority dates. Let's talk about priority dates. Priority dates in the green card process are simply the place in line for a U.S. visa. A priority date means the date when the first step of the green card application was filed, which ensures your place in line. And that is how the government determines who gets the green card at what time. Now, there are several categories for employment-based green cards, EB1, EB2, and EB3. So what this means is that, according to the new regulations, as long as an employer filed the first step in the green card and obtained a priority date, that foreign national can now more easily switch employers because they can maintain their place in line or their priority date from the prior employer. This is definitely something helpful in terms of labor market mobility, because previously an immigrant was absolutely scared to switch jobs, get a promotion with another employer, or move somewhere where their skills are better utilized because they were afraid of losing their place in line. And so that's what this new regulations protect against. That way, employees have more freedom to move between employers without fear of losing that place in line. The new regulations also provide for work permits or EAD cards for certain non-immigrants in the E3, H-1B, H-1B1, O1, or L1 categories in one-year increments, provided certain conditions are met. They are the beneficiaries of a green card petition, an approved green card petition. They still, the number 2 condition, they don't have an immigrant visa immediately available. All that means is that their priority date is not yet current, or all that means is that their place in line, they haven't gotten to the front of the line yet. And 3, can demonstrate compelling circumstances justifying a work permit issuance. It is worthwhile to note that spouses and children of the principal alien can also apply concurrently, but evidently they cannot be granted a work permit unless the principal application is also granted. That's just common sense. Grace periods for certain non-immigrants. Of almost all the other regulations, I would have to say this is very helpful, because there used to be the case that so many immigrants, if they get terminated from their H-1B employer early, they would have absolutely no grace period to wrap up their affairs and leave, or pursue a new visa status. Their H-1B status is terminated from their employment, either because the employer decided to terminate them, or they got laid off, or because the employer went out of business. Tough luck. They would have to pack up and leave immediately. Not so now. Now, if their employment is terminated early, before the date when their visa status was scheduled to expire, they would get 60-day grace period so that they have enough time to wrap up their affairs and try to either leave back home, or else jump on another visa status, or else obtain sponsorship from another employer. Even if they weren't terminated, but let's say their visa status naturally expires and there's nothing else after that, it used to be the case that tough luck, they wouldn't get any grace period, but now they would get 10 days to figure out what's their next move. Next slide, as to other H-1B and employment-based changes. So the regulations also work to allow for easier H-1B portability, such as change in employer or concurrent employment. It clarifies which institutions qualify for CAP exemption. It clarifies how and when H-1B time can be recaptured after trips abroad. It also clarifies and streamlines H-1B extension petition past the maximum 6 years for those with pending or approved employment-based immigrant visa petitions. There were other technical changes, basically all aimed at ensuring more freedom to change employers and provide employers with more options for employing such workers. Next slide, as to the 240-day rule. This rule allows now for certain non-immigrants to continue working in the U.S. if their status has expired, but their employer filed timely an extension of such status. That would apply for categories, a lot of employment-based categories, such as E1, E2, H1B, which is the most common, H1B1, H2A, H2B, and a bunch of others. Evidently, even if it's USCIS adjudication times that prevents, that delays the process of adjudicating an extension, USCIS would just allow it even out of discretion to renew automatically for 240 days. But it's nice to have this 240-day rule on the books, because there used to be the case, again, the reason this rule even exists is because there were so many cases of timely filed extension applications. By timely filed, I mean anything filed up to even 1 day before the deadline of the expiration of that status. So there used to be a lot of timely filed employer petitions for extension of H-1B, let's say, yet governmental processing time got in the way. And what do you do during the time that USCIS takes its dandy time to process? Well, there used to be, in certain circumstances, there used to be the case that there was a gap in employment. And so this 240-day rule is meant and targeted at reducing the likelihood of gaps in employment, just giving you an automatic extension of 240 days even before USCIS gets around to adjudicate your H-1B extension. Okay, so that ends the good news as to regulations passed in January. As to things passed recently as last Friday, premium processing of H-1B petitions has now been suspended by the new administration as to any H-1B petitions filed after April 3rd. Evidently, as we speak, we are in full H-1B visa season, because every year we have a deadline of April 1st, and this year will be April 3rd because April 1st falls on a Saturday. So this year we have an April 3rd H-1B season, and all of us immigration lawyers are now working hard to submit new H-1B visa petitions for employers. We just found out we can no longer use the premium processing service for processing them after April 3rd. What does that mean? Well, I have to explain to you what the premium processing meant before I can explain to you what it means to be without it. Premium processing was a very nice service to employers for an additional $1,225 paid to USCIS to process an H-1B petition in 15 days. That service ensured that the employer knew pretty quickly whether they can count on that foreign national labor or not, because H-1B petition may equally be denied. So it was a nice way to know immediately whether, as of October 1st, you would be having access as an employer to that H-1B applicant or not. Now, because of the suspension of the H-1B premium processing, this means that employers can no longer predict as well what foreign nationals, who of their foreign national workforce will be available on October 1st and who won't. Why? Because under regular processing, instead of 15 days, it would take anywhere 4 to 6 months, and I've seen sometimes even longer processing than 6 months. So in other words, if you petition on April 3rd for an H-1B worker to start working on October 1st, it may be the case that you won't know until even past October 1st if that person is approved or not. This is throwing a lot of uncertainty into the process, and more than that, it affects international travel for such H-1B applicants between April 3rd and October 1st. Why? And I'm going to explain something highly technical. Right now, as I submit an H-1B petition on behalf of an employer, I have to indicate to the government as of April 3rd whether my applicant, the H-1B applicant, will process in the U.S. or at a consulate abroad. The decision as to whether to process in their status inside the U.S. or at a consulate abroad is driven by their international travel considerations. In other words, if they're going to travel between April 3rd and October 1st internationally, I need to know, because then we are forced into consular processing. Okay? If they're going to say, you know what, I don't want to take any risks, I'm not going to travel, then we could do change of status in the United States. Okay? Now, with the suspension of premium processing, that choice is the choice for change of status. It's becoming way more delicate now, because if in the past you knew by mid-May whether you are approved or not, and therefore you could structure your travel plans accordingly, now you don't know until October 1, if you're, or so, September or October, until that you're approved or not. So there's much more risk and uncertainty in how people will structure their travel. And so most immigrants, most of these H-1B applicants tell their employer, I am just so scared that I'll be stuck abroad that I'm just not going to travel. But what do you do with someone who's required to travel for work? So that's a pickle. So in other words, international travel plans for H-1B applicants have just become way more risky because of this premium processing suspension, and also the predictability for employers of having this person around or not in October 1st is also up in the air, since you won't know if they've been approved or not until then. And that concludes my presentation, and I'm now particularly curious about your own questions, because all of these concepts tend to be a little abstract until you have actual scenarios that could illustrate how these concepts play out. Just generally speaking, there's a lot of strategic considerations going into H-1B application petitions, or generally into any type of immigration counseling. And these days we have to be even more practical than in the past about how we deal with the hirings of foreign nationals. I welcome your questions as to anything that's on your mind these days, even if it has to do with what I just presented on or something completely different. As long as it's within the field of immigration law, I should be able to answer. So go ahead and answer. Okay. So if you want to ask any questions, you could use the you could write them in the questions box of your webinar toolbar, or can we call them in? No, we can't call them in. I suppose that the only way to ask a question is to put it in the questions box of your webinar toolbar, or else you have my contact information on the presentation, and you could always give me a call if you have any questions. If it's at all, if the questions are all related to the upcoming H-1B season, and if you have candidates that you're contemplating for the April 3rd deadline, I would advise calling me sooner rather than later, just due to the fact that this is really, we're almost in the final stretch before submitting petitions, so we're in a little bit of a time crunch. Okay, given that there are no questions, I'm looking forward to any questions you might have via phone, and with that, I would like to thank you very much for listening. We have come to the end of our program. Thank you very much for joining us. Again, you will all be receiving an email with a link to today's presentation along with a PowerPoint presentation. Thank you very much.